A quite common question is to be asked when somebody finds out that you do estate planning or elder law. They go, okay, I know I need to do something because the vast majority of all adults do not have a will, a trust, a power of attorney. They say, I know I need to do something. Here's my question. Do I get a will or do I get a trust? Which is better? To which I usually respond, I have no earthly idea. And they kind of look at me like, what do you mean you have no idea? Well, I don't know. What is it you're trying to accomplish? How much do you have in the way of assets? Do you have children? Do you have children that you're worried about? Maybe they'll get divorced. Maybe they don't manage their money so well. Do you have a child with special needs and they're getting some type of government benefits? What are you trying to do with that? Are you worried about long-term care? So all these different questions. And once we know the answers to these questions, and I've just scratched the surface on this question, but once we have all the answers to a whole list of questions, then we can say, okay, now I know what you're trying to accomplish. Now, here's how we get from where you are here to where you're trying to go to. Here's the path. That may mean a trust, revocable or irrevocable, maybe both. It may mean a will. It may mean a trust and a will. And I'll say this, normally if we do a trust, I can't think of any situation where I've done a trust and we did not also do a will unless they already had the will. Because a lot of times people will go to an estate planning lawyer, they'll get a will, power of attorney, and then they come to us because they realize that's really not going to help them with long-term care, with getting VA pension benefits, getting Medicaid benefits, or protecting their assets from lawsuits, from children being divorced, things of that nature. So if they already have a will that's perfectly fine, well, we're not going to redo it. We just do a trust. But if you have a trust, you're almost always going to have a will because you might leave something out of the trust. The will take care of it, or the will pour it over into your trust. Imagine you have a pitcher, whatever you don't put in your trust is in that pitcher. You pour it into, like you're pouring water into a trust. So do you need a will or a trust? I don't know. It just depends on what your situation is. I will tell you this, the time to figure out the answer to that question is not when you're, as a friend of mine says, horizontal. You need to do that when you're vertical, when you're standing up, you're competent, you can think, you can make decisions. Not when you're in the hospital room dying, not when you're dead. It's too late at that point. So do your planning while you can, because that's the right time to do the planning. When you're horizontal, so to speak, you really have very few choices. And a lot of times it's going to be a situation where the state of Alabama provides your plan. They're going to provide who gets your stuff. They're going to provide what happens if you're incapacitated and you can't make decisions, assuming you don't have a proper trust or a proper power of attorney. The state will decide. Conservatorship, guardianship, very expensive to go to probate court to get all that. So make the decisions now and decide what is it you want, and then we can help you figure out, here's where you are, here's where you're trying to get to, how do you get there? What's the best way to do that? If we can help you, give us a call, 205-879-2447, or you can go to alabamaelderlawyer.com. Thank you.